Every day in the USA, people find themselves in court.
This is what I've entitled a sentence review in the matter of People versus Joshua Stephen Driscoll. That's you, sir?
Yes, sir.
Mr. Driscoll, I spoke with you a little while ago and set this matter for a sentencing review hearing, but I didn't know what else to call it. Let's go back to the beginning. You're charged in a felony complaint with assault with intent to do great bodily harm by strangulation and domestic violence that allegedly occurred in August of 2021. That matter was reduced at, I believe, the pre-exam conference to a misdemeanor charge of aggravated assault. It started as a prelim on Judge Patterson's docket, somehow came to mine. We got adjourned. There's some newly discovered evidence, and then there was an issue because we needed a special prosecutor, and I believe the special prosecutor was going to be here. Mr. Marvin had represented Mr. Driscoll prior to the election, and then once Mr. Marvin was elected, we had to get a special prosecutor, so the case dragged out for a while. Lindsay Shower, who had been an assistant prosecutor here in St. Joe County, was appointed. The defendant pled on October 21st to aggravated domestic violence. So I adjourned the matter for sentencing. She had to go to the hospital. I wanted hospital information, restitution information, the police report, and victim input. And so I set the matter for sentencing for November 2nd of 2021. The defendant was sentenced at that time with Attorney John Bush on a charge of aggravated domestic assault to 13 days in jail, credit 1, and a deferred 12 days of jail. And he was under other conditions. He violated that probation, and there was a probation violation petition filed in December of 2021 that indicated he'd failed to report on a monthly basis, failed to pay fines and costs, failed to participate in the use of drugs or alcohol, or failed to abstain from the use of drugs or alcohol, failed to participate in treatment. Basically, shortly after he got put on probation, just sort of went off the map. At the probation violation arraignment in January of 2022, he pled not guilty, and the matter was set for a probation violation hearing. Defendant was found to be in violation of his probation, positive for marijuana, and he was given a jail sentence of 30 days, and he was to turn himself in at the jail on, I believe, March 5th of 2022. Looking for that actual judgment. On March 3rd of 2022, he was ordered to 31 days jail, credit 1, leaving 30 days to serve. So he was sentenced. He was to turn himself in at 3 p.m. on March the 4th of 2022. And he didn't do that. I continued the probation, so I would have the authority to alter the sentence if he did not appear. He did not appear. A bench warrant issued for his arrest on March 30th. Daniel, his probation officer, tried to run him down, wasn't able to do so. March 30th of 2022, the bench warrant issued. I think Mr. Bush was listening at the previous hearing, and then nothing else ever happened. Now the appearance was filed. The defendant was AWOL, and he got arrested about 20 days ago. So we did an arraignment with Keith Stickley, the chief public defender, and I canceled his bond under the conclusion that he'd already been sentenced 30 days jail, credit 1, 31 days jail, credit 1, that he owed 30 days of jail. I didn't pursue a further probation violation. I didn't pursue a contempt for his failure to appear. I simply set the matter for a review today. But in my mind, Mr. Stanley, the sentence has already been imposed in this matter. The defendant, for his own reasons, didn't show up or ever come back. And when he was apprehended, I just left the original sentence. Discussed this earlier with Judge Pattison. So, well, if he wants a hearing, I guess you can find contempt and do 93 days in jail or pursue a probation violation because he was still on probation at the time he failed to appear. Anyway, my goal was to just put this thing to rest. He's now done 20 days of the 30. He gets 5 days a month good time. And if nothing else happens, he'll get out of jail in 5 days, at which time I would revoke his probation because he's been a very poor probationer. So having said all that, what's your position here?
Well, respectfully, Your Honor, as I told the court when I came into the courtroom, court asked if I needed time to meet with my client. The deputies made him available to me. And I indicated to them and to the court that I came down here on January the 12th. I met with him at length. And I believe I still have his authority to speak for him here. I want to be cautious how I express this to the court because I don't want the court to perceive, and I truthfully don't believe as an officer of the court, Mr. Driscoll wishes this to be perceived as an excuse. But if there's ever been a client, I have seen a vast change of attitude from a year ago until today, it is this young man. And there's a reason for it. And I'll try to be brief in my comments because I understand what the court's saying and where we're likely going here. But just in terms of respect for this court, I think the court's entitled to know this. The court is correct. I did file. I was retained by the family almost a year ago, particularly by his mother, because she feels the underlying charges didn't have any real merit and the complainant case was lying and just very supportive of her son. And to a degree, he supported that. So what he wished to do is have me not just handle any probation violation or resentencing, but try to set it aside. And I think it's fair to say at that time, he was certainly listening to his mother, and he was of the opinion that he didn't think he'd been treated fairly. I then made arrangements, and he was going to meet me down here. I contacted the sheriff's department, the court, the prosecutor's office. We had an agreement that I was going to turn him in on February the 14th, and I was actually literally driving down here February the 14th of 2023. And I was literally driving down here when I got word that he simply had panicked by some events going on in his life and was so concerned about being locked up and kind of this overall feeling that his sentence wasn't justified because the underlying facts, not because the court made an error, but because the complainant presented these facts, and he did not show up. I turned around and headed back to Grand Rapids. I documented everything in my file in a memorandum. What I'm more interested in talking about and trying to convey to the court. So when I came down here to find out what happened, why he did that, and what's happened in the year, I was shocked because I almost thought I was talking to a different client. Once he was incarcerated because he had served about 16 days or 14 days in jail when I came to see him, just a vastly different attitude. Having been locked up was quite an eye opener for him. He realized how much he'd hurt his family because in the interim, some things have developed that are very difficult for him. He has 2 children, who is a boy whose birthday is 12, he's 11 years old, and a young lady, 7, she's 16 years of age. While he has joint custody, for all practical purposes, he has full custody because their mother has significant drug abuse problems and is kind of off the rails. And so he has been responsible for raising these kids. And from last year to this year, he's developed an entirely different relationship with his kids and feels a tremendous sense of responsibility to them. So now all of a sudden to have been locked up is really been an eye opener how much he's hurt his family by some very poor choices on his part. And he's acknowledged to me those poor choices. It's just a totally different attitude from this young man from when I met with him a year ago. The other second factor that's going on in his life, and I have some documentation to confirm it, that the court would like to review it, but his father also has a very rare type of blood infection, cancer, and is not expected to live very long. And he was providing a great deal of care for his father too. So as a result of his very poor, immature choices, his words when I came to see him last week, not mine, he realizes he's really hurt his family. So he's expressed to me, and he'd like to express to the court, we're not asking for a hearing. I indicated to him we could certainly have a hearing. We could test these issues. He wished last week and instructed me to directly tell the court he wanted to apologize to the court for his conduct, his irresponsible decisions a year ago, and he realizes how much the court that has hurt the court and it's hurt his family. And he simply wishes to get back to his family so he can attend to their needs as soon as possible. So not by way of an apology or an excuse. Well, it is his apology, of course, but not as an excuse, as an explanation for why he feels so different today than he did February of 2023. And he hopes the court would simply accept that. He expressed it himself, and wishes the court would just go along with the original sentence and not consequence him more than that. I did explain to him the court's latitude, and since he was continued on probation, in fact, he could face more confinement, and he understands that, but he still wishes to accept responsibility, apologize to the court, and hope the court will be lenient so he can get back to his father and children as soon as possible. These children don't have, for all practical purposes, anybody else to really properly take care of them. Thank you, Your Honor.
Thank you. Mr. Driscoll, is there anything you wish to say?
I want to right my wrongs, Your Honor. I want to become the family man that I need to be. It's been very hard on me, having this over my head and trying to be the father I need to be and the son I need to be. So, I've learned a lot in the last few weeks of being here. I actually was saved the other day. And I want to continue that. I want to take what I've learned home to my children as well. And I'm very sorry, Your Honor.
Well, we can bring this to a close. Mr. Stanley, I'm not sure how much of this is methamphetamine. What we find often is when you lock somebody up for about 2 weeks, they turn back into the person that they used to be. I can see the difference with Mr. Driscoll right here, and you saw it yourself. So I think we were dealing with some other issues that are outside the purview of this. I was not concerned about the veracity of the plea. He was charged with strangulation offense. The complainant was injured. She went to the hospital and was treated. The daughter witnessed what happened. He pushed her into a gate. And then the son got in there. And it was not a very good situation. It was reduced to a misdemeanor. I adjourned it to get more information. I did the sentence. I gave him 13 days, credit 1 with no additional jail time, and put him on a probation. And I believe because of methamphetamine, he didn't do anything. He just sort of went, I don't know, he felt he was treated unfairly. I thought he got a sweet plea offer and a generous sentence from me. So then I gave him only 30 days and the courtesy of allowing him to turn himself in, which he didn't do. And then he had an excuse for everything. And the excuse is you need to look in the mirror. So you got 20 clean days You've had some spiritual exploration. And I don't see the need at this point to pile it up, but I'm not very happy about it. You wasted a lot of our time, the court's time, the jail's time. This would have all been over with 2 years ago. If you just shown up, they probably would have made you a trustee and you would have been out in about 17 days. Well, so I'm just going to confirm the original sentence of 3/2/22, 30 days. Now 31 days. No, 30 days, credit 20. Gonna revoke your probation. This probation was a total failure. One of the concerning things about this is he lived right at Three Rivers at the same house where all of this went down. And it managed to stay under the radar 4 blocks from the police department for 2 years. But now this matter's done. I think you've been struggling with some addiction issues. I think your family's suffering. I think this is a good start for you to kind of turn things around. I'm not going to continue to supervise this as a probation. You never did anything you were supposed to do. And then I gave you a break and you poked me in the eye with a stick. And then you wanted to talk about it at the time of the hearing. Yet again, you had an excuse for everything. You're much more rational and reasonable. And this is the way I remember you in the past. So I hope you can continue this for your sake and the sake of your family. The original sentence remains 30 days. You now have credit 20. Your probation is revoked, and I'm not going to try to collect any money. If you get your ship right, I won't see you again. If you don't, I'll see you by 4th of July. So I hope you can do that. All right, you're good to go.
Your Honor, thank you for the court's
Thank
patience.
you.